maintain silence, but that is not right.
A gentle reminder again, kindly please keep your phones on silent, and now that you're in the room, you cannot leave. Thank you. Please stand.
Yes.
Please stand. I would like to give a warm welcome to our judges. Our judges for this round are Justice Mahesh Sona, Justice Fairfield Rivero, and Justice Varuki Sam. Your Lordship, the petitioners are Team 07 and the respondents are Team 14. The petitioner speaker 1 will be taking a total of 20 minutes. Petitioner speaker 2 will be taking a total of 20 minutes. And their rebuttal is they reserve time for 5 minutes. The respondent speaker 1 will be speaking for 22 minutes. Speaker 2 will be speaking for 21 minutes. And they reserve 2 minutes for sir rebuttal. During this round, use of mobile phone or any other electronics are strictly prohibited. Passing slips must be done only by the cursor, and if any literature or documents need to be passed on to the judges, please do so to the petition. Thank you. If the petitioners are ready, we may begin the petition.
Now, before we start, we don't have to know which is the number of the team. We have to know.
Yes, sir. The petitioners are Team 07.
Team 07. And
the respondents are Team 14.
14, exactly. 7, 14.
Yes, and the respondents are 14.
And I assume we are not supposed to know the names of the participants.
No, sir.
That's totally okay. Keep it a secret.
My Lordship, when are ready.
Okay, now I think petitioners can start.
May I please the court? Counsel seeks permission to address the bench collectively as my lord. Grateful, my lord. I am appearing as counsel for the petitioner in and Devanand Joshi versus State of Dalmur, along with my counsel and reflection. With your lordship permission, I would like to proceed with the facts of the incident. Grateful, my lord. Am I audible?
Please be here. More than
Here goes the facts of the case. Danpur is a state constituted of three ethnic groups, that is Maitri, Bangas and Kurmis. Maitris lived in the valley areas, whereas Bangas and Kurmis lived in the hilly areas. Bangas and Kurmis lived independently and autonomously, and the tribal chief decision was final and binding on all its members. And the chief jurisdiction was only extended to Bangas and Kurmis when there was conflict between the two tribes. And after being defeated by the British, then King of Kanpur, Raja Ram Singh handed over the administration of hilly areas to the British agent. In the year 1949, then King of Kanpur, Raja Ram Singh signed an accession agreement with the state of Indus. In the year 1969, Kanpur became one of the part of state of Indus. This led to armed conflict in the year 1970s because several sections of Kanpur raised objection for such merger, and they advocated for a separate land called Banglaland, and Kurmis also advocated for the separate state. As a result of this, in the year 1980, the state of Kanpur was declared as area of disturbance by state of Indus, and armed special forces were inflicted under this region. By the year of end of 2005, peace was somehow established, but still Kanpur continued to suffer from innumerable underground organizations as well as ethnic clashes. And the political parties further tried to intensify the matter for their political seats. Up to 2018, state of Kanpur was ruled by local political parties. In the year 2018, IPP, the national political party, came into power, and it was known for narrative of its nationalism. Its main endeavor was history of Kanpur not to be retold through personal narratives. In order to fulfill this endeavor, the state of Kanpur issued an order under the Higher and Technical Education Department prohibiting the publication of books on history, geography, tradition, culture without the prior approval of the committee constituted by it. Meanwhile, Mr. Marine Zamir, a great scholar who obtained his PhD from Yale University in archaeological anthropology, has written a book, History of Kanpur. This in turn was published in India on September 1, 2022 by a renowned author, Maxis International. The contents present there in the book were King's jurisdiction was only confined to valley areas and not the hilly areas, and the tribal chiefs were not the signatory to such accession agreement, and hilly areas jurisdiction is neither a part of Kanpur nor the state of India. So this reignited the demand among Bangas and Kurmis for the separate state. And the committee on September 30, 2022 placed Mr. Marine Zamir book before the committee. And the committee, after scrutinizing, opined Mr. Marine Zamir book as false and baseless. Hence, Mr. Marine Zamir was arrested under 124A of IPC for violation of such order. Therefore, Mr. Marine Zamir is before this honorable court filed a writ petition under Article 32 challenging the constitutionality of the order as well as his arrest under Section 124A of IPC. Further, Devanand Joshi, a renowned author who revealed details of his forthcoming book, Ravan's Ramayan, through his Twitter blog account, where it appears that Ravan justifies abducting Sita and the questions of quality.
just a moment, please. Can you give us a pad to write, please? We don't have a pad to write. No, not a pen. Right? Pad. We'll make some notes. Yes, please go ahead.
Devanand Joshi, a renowned author who reveals details of his forthcoming book Ravan's Ramayan through his Twitter blog account, reveals that Ravan justified abducting Sita and also questions of qualities of Ram killing Vali and disbelieving his sister. This in turn led sparked the mass protest among Hindu communities, and owing to the threats and protests, state of Kanpur issued two orders to Devanand Joshi and Chinmay Publication House. The first issue to submit the manuscript of the book before the committee, and the second issue to ban the book until the committee gives the approval. So Devanand Joshi has filed a writ petition before this honorable court, challenging the ban on his book. So both the cases of Mr. Marine Zamir and Devanand Joshi are clapped before this honorable 7-judge bench to decide. If your lordship is satisfied with the facts of the case, I would like to proceed with the issues of the case.
Please do.
Grateful substantiate my case. The first issue, whether the order passed by Danpur government on August 15, 2022 violates the fundamental rights enshrined in the Constitution of India. And the second issue, whether section 124A of IPC is violating the fundamental rights enshrined in the Constitution of India. And the third issue, whether the government order shall require Joshi's book to be submitted for pre-publishing review and whether pre-censorship of this type is violating of fundamental rights. And the fourth issue, whether the imposition of section 124A of IPC is in contravention of the order of the Honorable Supreme Court given by a three-judge bench in S.G. Bombarker's case on May 11, 2020. With your Lordship permission, I will be proceeding with the issue number 1 and 2 and my co-counsel will be proceeding with the issue number 3 and 4. Grateful, my Lord. Issue number 1. Whether the order passed by Danpur government on August 15, 2022 violates the fundamental rights enshrined in the Constitution of India. In my respectful humble submission, the order passed by Danpur government on August 15, 2022 is the violation of fundamental rights enshrined in the Indian Constitution, Your Lordship, because the order passed to prohibit the book on publication of history, geography, tradition, culture, in turn is forbidden by fundamental rights, that is the Golden Triangle, Article 91A, Article 14 and Article 21, Your Lordship. Especially the mother of all liberties, that is Article 19(1)A, Your Lordship. And if I look into the order copy passed by Danpur government, the order copy itself is imprecise, vague and having inherent ambiguity. If my Lord can, I would like to bring my Lord's focus to the para 2 of the order passed by Danpur government, that is, any person desirous of publication of book on history, geography, tradition, culture may file an application before Director of Higher Technical Education Department. My Lord, I would like to stress on the word may from the second para. The word may from the second para implies that the order is just discretionary or directly in the nature. It means the liberty of speech is in the second para. If my Lord can look into the third para of the same order, any publication of book in violation of para 2 above shall be liable to be prosecuted under the relevant law. My Lord, here the word shall in the third para implies that the order is mandatory in nature. So, here para 3 is giving you the liberty and the para 3 is prosecuting you for the liberty given in the second para, my Lord. So here, para 2 and 3 of the same order are contradictory and conflicting in nature, my Lord, and the order is not precise.
Maybe ask you a question.
Yes, sir.
Under what provisions was this order issued? Under what provisions of law was this order issued?
The object of the order.
Not the object of the order. This order must be coming from somewhere. Government must be
There is
issuing executive instructions, subordinate legislation,
There are-
legislation. What kind of order is this?
The order is not being passed by any parent act, Your Lordship. I come to that point, my Lord.
Then what is it? Is it an order under relatable to executive power under Article 162?
No, Your Lordship. Your executive order has been passed, but there is no parent act, Your Lordship, because there are no laws in India which deals with pre-censorship with banning of books before publication, Your Lordship, and my co-counsel will be dealing with that executive, Your Lordship. Careful perusal of last line of para 2, second para. Committee can convene its meeting as and when required. My Lordship, no specificity as to time limit for processing the applications have been given, Your Lordship. And will there be unanimity among the members of committee constituted by this order all the time, Your Lordship? And if there are difference of opinion among the members of the committee, whom shall it be addressed, Your Lordship? And the vagueness continues with the para 3, Your Lordship, that is any relevant law. It means no specific provision to which a person will be prosecuted here has been given, Your Lordship. This in turn is giving openness or oversight to the committee to decide under which provision to prosecute the person, Your Lordship. The order part should be clear and precise as it is stated in the case AKI versus Union of India, Lordship. So here the order passed by Danpur government is not clear and precise, Your Lordship. And here the order which is curtailing my fundamental rights that is freedom of speech and expression, is not passed by any parent act, Your Lordship. As it is given in the case,
But A.K. Roy wasn't it a matter dealing with preventive detention, which you are relying on? So that an order has to be clear that concept is acceptable in a preventive detention matter. But in such a matter also you are relying on A.K. Roy.
yes, Your Lordship, because here they have stated that in order to prosecute a person under a crime must be clearly defined. Crime also comes under the criminal law, Your Lordship, but order is also a law of crime. Law is a law, Your Lordship. Your Lordship, here the committee set by this order is exercising excessive arbitrariness which is not delegated by the parent act, Your Lordship, because it is unilaterally taking the decision, Your Lordship. And this honorable court do not accept the absolute discretion exercised by the administrative action as it is held in the case State of Madhya Pradesh versus Bharat Singh, Your Lordship. The fundamental rights can only be curtailed by administrative action if the power is delegated by the parent act, Your Lordship. Your Lordship, this order passed by Kanpur government do not pass the test of proportionality, Your Lordship, doctrine of proportionality, Your Lordship, because there is no proximate nexus between the object and the measure taken, Your Lordship. If my Lord can please look into the sixth line of the order, which tells the object of the order, that is, not to distort the historical facts, disturb peaceful existence. And the measure taken in order to accomplish this objective, Your Lordship, to prohibit the books to the community, which is not at all proportional, Your Lordship, because if the real object of the state is to maintain the peaceful existence, public order in the society, I would like to ask myself this question that the state of Kanpur is in turmoil since 52 years, Your Lordship. What is the state of Kanpur do from 52 years, My Lordship? No negligible response has been given by state of Kanpur towards the claims of the citizens, Your Lordship.
Is there a distinction between law and order and public order? When you use the expression public order, that is under Article 19, I presume.
Public order is nothing but peaceful coexistence or tranquility, public tranquility.
Okay, proceed.
So it is evidence of fifth para of the factual matrix that since 1970s there is armed conflict and there is objection of people, which is even going on till today. But the state never ever gave negligible response. It did not address the claims of the people. It did not justify as to what is true, and it did not disclose the accurate information about the accession, Your Lordship, which has led to such disturbance, Your Lordship. By this we can get to know that state of Kanpur is having no good governance or maintaining the transparency or accountability, Your Lordship. As it is mentioned in the case Siddharth versus Union Territory of Arunachal Pradesh, the government has a constitutional duty to consider and redress the grievances of citizens, which the state of Kanpur has failed to do so. Instead, it is trying to confine the roots by chopping up the freedom of speech and expression of the citizens, Your Lordship. And Your Lordship, the committee which is set through this order is not following the principles of natural justice, Your Lordship, because it is evident from the 12th para 4th line of the factual matrix that the committee which has opined Mr. Merrington in book false and baseless did not give justification for such rejection, Your Lordship. Did not maintain the grounds, Your Lordship, as it is said in the case Lal Singh Yadav versus State of UP. If the state government not mentioning grounds for order of forfeiture of book would be held set aside, the same has been repeated in the case Anand Chintamani Dige versus State of Maharashtra 2002, where the Honorable Court said that if notification failed to set out the facts on which the book was banned, then the order has to be held invalid. So here the order which is not giving any justification has to be set aside and held invalid, My Lord. And the order passed by Kanpur government is not in consonance with the preamble of Indian Constitution, My Lord, which embraces the liberty of thought and expression. And so I would like to quote Charles Braddock, who rightfully said that a better thousand-fold of abuse of free speech than denial of free speech. The abuse dies in a day, but the denial slaves the life of people and encounts the hope of peace. My Lordship, this is not only violating Article 91A, but also violating Article 14, Your Lordship, that is right to equality. because it discriminates between two classes of people, Your Lordship. The first class of people who intends to publish the book and the second class of people who intends to publish articles, newspaper, journals on the same subject matter, Your Lordship. The one who intends to publish a book has to place a manuscript of the book before publication to the approval of the committee, Your Lordship. But the one who intends to publish articles, newspaper, journals are not required to place before the committee for its approval, Your Lordship.
Why is it not a visible classification? Two different. One is everyday publication. The other is a book we publish for all time.
Your Lordship, the articles, journals, magazines, even they discuss about the same subject matter, Your Lordship. Sometimes about history, geography, tradition, culture, and that's what I'm saying. There may be intelligent differential, Your Lordship, but there is no rational interest. So hence it is the twin test of reasonable classification under Article 14, Your Lordship.
You have made your point.
So this impugn provision which violates the fundamental rights should be nipped, but if not, similar kinds of impugn orders will be passed by the state government which would ring the death knell of its fundamental rights, that is the golden triangle, Your Lordship. If Your Lordships are satisfied with issue number 1, I would like to proceed with issue number 2. Grateful, my lord. Issue number 2. Whether the section 124A of IPC is violating the fundamental rights enshrined in the Constitution of India. In my respectful humble submission, section 124A, which is law on sedition, is violating the fundamental rights enshrined in the Constitution of India, Your Lordship, because it again violates Article 91A, freedom of speech and expression, which is again the mother of liberties, Your Lordship. When one can look into the definition of sedition, sedition is itself vague, having inherent ambiguity and uncertain terms, Your Lordship. That is the definition.
Council, have we not already upheld the constitutional validity of this provision?
Yes, Your Lordship.
In Kedar,
In Kedar,
subject to the safeguards.
yes, Your Lordship. In the case that is Kedarnath versus State of Bihar 1962, Your Lordship, this the Honorable Supreme Court upheld the constitutionality of this, but then no amendments regarding to interpretation of definition was made, Your Lordship. And this court then was not aligned to the other fundamental rights or international laws, Your Lordship, because it was in the year 1962, Your Lordship.
Just because one argument may not have been considered, is that a ground to revisit the case and again examine the constitutional validity?
The section 16, under this section 124A, many innocent people are being harmed, Your Lordship. That is why even our client that is Mr. Marine Surveyor and Devanand Joshi are also being prosecuted under this, Your Lordship. So we are once again challenging the constitutional validity of this section 124A before this Honorable Court, Your Lordship. The definition goes this way: whoever by words either spoken or written through visible representation or signs brings or attempts to bring disaffection, hatred, contempt against the government shall be punished with imprisonment for life or imprisonment for 3 years above this time. Your Lordship, the term proposed in the definition such as brings or attempts to bring hatredness, disaffection are not clearly defined, Your Lordship. I would like to further elaborate on the point attempt to bring hatredness, Your Lordship. Your Lordship, if I'm just telling a plain truth, and if that is exactly the hatredness in the public, according to this definition, I will be prosecuted under this section. Assessing on the public reaction, Your Lordship, it is outright foolishness that how come I expect prudent man in the public domain, Your Lordship? And as it is given in the case Ramesh versus Union of India 1988 that effect of words must be judged from the prudent man and not those of weak or deflating minds, Your Lordship, or who set danger in every hostile point of view. And here, the vagueness and morally approved definition, Your Lordship, it continues with the explanation 1 and 2, Your Lordship. Explanation 1, Your Lordship, disaffection includes the disloyalty and all other feelings of enemy. Your Lordship, disaffection and disloyalty are completely two different words with different meanings, Your Lordship.
Council, after the Supreme Court upheld the law, frustrated the law, considering Article 19(2)(a), under 19(2)(a) there can be restrictions on free speech also. Law can be made restrictive. So you must show us why we must reconsider the earlier judgment. What are the new grounds available to reconsider the earlier judgment?
Your Lordship, this provision is causing chilling effect on my freedom of speech and expression, Your Lordship, which I'll be coming to that point, Your Lordship.
We'll give you another 2 minutes.
Yes, Your Lordship.
In the case Passenger versus Union of India 2015, Honorable Supreme Court struck down Section 66A of Information Technology Act, which caused a chilling effect on freedom of speech and expression, Your Lordship. And the definition suffers the voice of vagueness, and the term opposite was not clearly defined, Your Lordship. So, in the light of same way, Section 124A of ITC, which causes chilling effect on the freedom of speech and expression and suffers from voice of vagueness, and also where the terms are not opposite or not clearly defined, have to be held unconstitutional or struck down, Your Lordship. And here Mr. Medical has been moved under this section where it is not clearly defined, Your Lordship. As Economic versus Union of India, in this case it has been determined that in order to hook a person under crime, crime must be clearly defined, and the vague terms such as attempt or hatredness, disaffection, there is no possibility of practical implicability of such terms, Your Lordship. And it is not only confusing but also unnecessary to have this law, Your Lordship, because there are various other provisions dealing with the same subject matter, such as National Security Act, Your Lordship, Unlawful Activities Prevention Act, Your Lordship. So Section 124A is not in consonance with the preamble of Indian Constitution, that is again liberty of thought and expression, Your Lordship. And 124A also violates the fundamental duties, Your Lordship. Article 51AH, that is, which casts duties on every individual to develop scientific temper, humanism, and spirit of inquiry and reform, Your Lordship. It is even evident in the pre-independence era that this tradition law has been misused. Even great freedom fighters such as Mahatma Gandhi were prosecuted and convicted under this law, Your Lordship. Mahatma Gandhi, father of the nation, rightfully said that this impure provision is designed to suppress the liberty of citizens, Your Lordship. So here, Mr. Malik Kabir outlined his speech is just in the stage of advocacy and discussion and not in the stage of incitement, Your Lordship. So in democratic systems like India, every thought, every voice, every thought, every dissenting opinion also has to be acknowledged, Your Lordship. If not, it do not serve the purpose of democracy, Your Lordship. So this draconian law, which is crippling the active participation of citizens in all the spheres of society, violating fundamental rights, should be struck down, Your Lordship, and give wings to citizens to exercise freedom of speech and expression without any chilling effect, Your Lordship. So, if Your Lordship are satisfied with question number 1 and 2,
Thank you. We'll hear your first speaker now.
my co-counsel will be proceeding to case number 3 and 4.
You have used 2 expressions, chilling and crippling. We'll note that.
And it was immense pleasure appearing before Your Lordship.
The council seeks permission to testify.
Yes,
Walk through to Lordships. The council seeks permission to address the best to the Lordships. Your Lordship, before I begin, I would like to submit the complaint, which has the compilation of all the observations that during the course of police submission have been made. And Your Lordships, every time, very important time, want to verify the facts, authorities, you should much of it. Your Lordship, this is council number 2, appearing on behalf of the petitioner in a recent case of Malik Jamil and Jamal versus the state of Nagpur, as the addition issue of 3 additional report of factual matters. If I may proceed, issue the remand with Your Lordship, due permission,
please go ahead.
much of it. Your Lordship, the council for the third issue is whether the government order shall require judicial book to be submitted for pre-publication review and book to be submitted and whether the pre-session of this kind is violating fundamental rights. Your Lordship, the council for
You want to argue without a mic?
I am not.
Okay, fine. We can hear you. You are loud and clear.
That's all right. Your Lordship, the third issue, whether the government order shall require judicial book to be submitted for pre-publication review and whether pre-censorship of this type is violating fundamental rights. Your Lordship, the council for petitioner most reverently submits with the honorable court that the government order requiring judicial book to be submitted for pre-publication review and pre-censorship of this type is violating fundamental rights. As Your Lordship, as stated by my co-counsel, this order prima facie infringes the right to equality as well as right to freedom of expression guaranteed under Article
Council, not to derail you, but why should we look into this matter under Article 32? would have gone under 226.
Pardon me.
Why should we look into your grievance under Article 32 by you directly approaching us? You would have always gone under 226.
Your Lordship, here this is concerning the state of Nagpur, Your Lordship. If any individual who wants to publish a book in this can be published, but not in the state of Nagpur. So it is clearly breach of equality because the constitution of this clearly
Agree with you.
Your Lordship.
Why should you not prefer, or why should we not relegate you to the jurisdiction under 226?
And the question of fundamental rights are involved, Your Lordship. At the same time, the include section, that is section 124A, regarding the question of law has arrived, and so apex court can be the is a suitable court to take decisions on such matters. Where question of law is involved, at the same time fundamental rights are involved.
So according to you, Article 32 you can come because your fundamental rights are involved.
Fundamental rights, at the same time, Your Lordship, questions. Your Lordship, when it comes to NC Mohammad's case, Your Lordship, there is Kedarnath dictum as well. So regarding that, if we approach High Court, maybe that will not be the suitable place where we get the justice, Your Lordship. So apex court, wherein 7 judge bench is the right place where we can get the justice. That is why we have. So I have answered.
Okay, go ahead.
Much obliged. Your Lordship, it is based on the right equality because of intelligible differential, that if any material published in the form of book, then it is subject to censorship, whereas if it is published in the form of articles, journals, so Your Lordship, there may be intelligible differential between the two, but the object ought to be achieved in the same, Your Lordship. So it clearly violates the two test.
When you say intelligible differentia, what is the intelligible differentia in publishing a book and publishing an article in a newspaper or magazine?
Your Lordship, the same can be published in the form of whatever Baron Jamil has published. The same he could have published in the form of, if he had published in the form of journal or article, then it would not be subjected to censorship. And same goes for Devan.
Since you have used the expression that there may be intelligible differentia, what is the intelligible differentia between publishing a book and publishing an article in a newspaper? Can there be one?
And Your Lordship, my contention is there may be intelligible differentia, but rational nexus it is missing, Your Lordship, because the objects ought to be achieved. Of course, they need distortion in history, so that it clearly is the twin test of reasonable constitution laid in the state of West Bengal versus Anwar Sarkar case, Your Lordship.
Okay, go ahead.
Indeed, Your Lordship. So coming to freedom of speech guaranteed under Article 19, Clause 1A, Subclause A of the Constitution, Your Lordship, I agree it is not absolute, but there is no absolute power to curtail it either. The state is permitted to impose only reasonable restrictions. The first requirement for that is that such restrictions can be imposed only by act passed by competent legislator, not through mere executive order. In this, in the instant case, Your Lordship, it's a mere executive order which does not even have parent law. Your Lordship, at the same time, even though it is true that in English every executive order does not have prior legal sanction for its validity, but the same is not true with respect to those which seek to restrict or curtail fundamental rights. And here it's restricting or curtailing an individual's fundamental rights. And in this regard, Your Lordship, I would like to refer to the case of Chintan Law versus State of Madhya Pradesh, where it was held that restrictions can be imposed by law only and not an executive order. Furthermore, it was held that it is the judiciary and not the legislature which has to finally judge the reasonableness of the restriction, and that is exactly why we are before challenging. And such orders.
Is law defined anywhere? Is the word law defined any enactment or the constitution or anywhere?
Defined, Your Lordship. Article 13 is defined,
In Article 13,
which says any law is inconsistent with a.
I am not asking, I am asking whether the expression law, is it defined anywhere under the General Clauses Act, under the Constitution?
Your Lordship, I would like to refer to Article 13, Clause 3, Your Lordship, in which, in this article, unless the context otherwise requires, law includes. So law is defined.
Law includes what?
Law includes ordinance, order, bylaw, rule, regulation, notification, custom, or usage in the territory of India, the course of law.
Okay.
And since the definition includes an order, what is wrong in this. You had earlier argued that it should be a law means a law framed by the legislature. Now the definition which you read out to us, law includes an order.
But it is not delegated, Your Lordship.
In any case, if you look at the definition under 13.3, it says in this article, unless the context remains. It is concerning Article 13. 19 is different.
18 is different. 19 and 14 are different. It is only limited to Article 13. Can I proceed with that?
Yes, please go ahead.
Right, much of it. So, Your Lordship, the second, as such orders must necessarily have a section of law. So, the executive order expression does not have legal sanction. And the second requirement is that restriction imposed should be in the interest of any of the 8 grounds mentioned in Article 19 Clause 2, and the third such restriction must be reasonable. Your Lordship, though looking at the stated reasons for issuing the order in question, it may be obvious that the same is issued in the interest of public order. Imposition of free censorship on all goods on aforesaid subject is totally disproportionate and unquestionably unreasonable, Your Lordship, as there is no timeline for processing such application, Lordship.
It by counsel, nobody is convicting you. All that this order says is that if you publish something like this, then the state will launch a prosecution against you. In the prosecution, you can prove your innocence.
In case if the vice
there is a presumption of innocence.
I have a good question. Yes, I can ask you. So, if the particular book is subject to approval, and it gets approved, but if it gets approved, what is the timeline? There is no timeline. When will it get approved? So that there are question. So this order in question, it lacks transparency. It has no fixed time limit, Your Lordship. So it is in no way coercion, Your Lordship.
There are several decisions of the court. Say that if no timeline is prescribed, then within reasonable time. If they don't do it within reasonable time, you can always go to the High Court and seek a mandamus.
Indeed, Your Lordship, but
Please strike it down.
Your Lordship, section 19 of CRPC through which a state can ban books. They have that option, Your Lordship, but still they have passed such an order which makes it confusing, Lordship. So that is the condition. Through section 95 CRPC, the state has but still they have passed such an order which is again, there is no time limit. So that makes it a bit baffling. So moving further, Your Lordship, when the state claims, so I move further, Your Lordship, experience also shows that accurate facts and truth often emerge from clash of opinions, and there is the order in question doesn't allow that, Your Lordship, because there are only 10 members in the committee, so actually there is no transparency as well. And moving further, both Universal Declaration of Human Rights and International Covenant on Civil and Political Rights, ICCPR, states that everyone has the right to freedom of opinion and expression, which includes opinion of a political, scientific, historic, moral, or religious nature. But in the instant case, any opinion which is contrary to what the state believes, Your Lordship, shall just be cancelled, as in the next case of
pausing here, can we read international covenants into the fundamental rights?
In the Lordship,
Now you are quoting international covenants.
Article 19.
Now we have a constitution. Can we read those covenants into the fundamental rights?
Indeed, we can read, Your Lordship, as Article 19 defines, and in this is signature to that, and we can read, Your Lordship. Can I proceed further, Your Lordship?
Yes.
So, moving further, Your Lordship, this pre-sentence of this type is not only objective and
Basically, the Supreme Court has read into Article 21, right to life, the various international covenants have been read into Article 21. Now you are relying on Article 19.
of IWCPR. Article 19 of Human Declaration of Human Rights. I am referring to that article.
Which,
Article 19 of Universal Declaration of Human Rights.
no, therefore, we are asking you a question whether the international conventions, including ICPR, can it be read into the chapter of fundamental rights?
Yes, Your Lordship.
Because nowhere Article 19 or 21 says.
Indeed, Your Lordship, that of course it doesn't say, but that can be read, Your Lordship, as coming to fundamental rights is taken from Bill of Rights from US, Your Lordship, so it can be referred to.
Okay.
Moving further, Lordship, Your Lordship could refer to paragraph number 9 of the Moot proposition, where it clearly states that books published on history, culture, tradition, geography of the state contain material which either distort facts or disturb the peaceful coexistence among the various communities or the state or both, Your Lordship, nowhere the word faith, religion or belief is found. And if Your Lordship could read paragraph 14 of fact sheet, from this it is very much clear that my client Devanand Joshi intends to publish a book called Ravan's Ramayana, Your Lordship, and this this book is not yet published yet, and which in no way is connected to any of the genre mentioned in the article. Not even history, be it geography, tradition, culture, nowhere it is connected with any of the mentioned subject, Lordship. And but still, the book is referred to the committee for approval. So clearly, Lordship, the state which passes an order, it is deviating from its own order. So it's like telling something and doing something else. So that is exactly what is happening in the Indian case, Lordship. And going further,
isn't there some decision we have taken in the past which says that when it comes to books, there cannot be any free censorship?
Lordship,
I recollect in the decision of the Supreme Court, which says that when it comes to movies or even perhaps dramatics, I'm not sure about drama, but about movies there could be a free censorship. But about books, there cannot be a free censorship.
that is exactly what.
But which is that decision of course? You point out, is there a decision where we have already taken this view?
AK of course can be. And Your Lordship, moving further,
Wonder if your researcher can actually point out that paragraph to us, that would help. Anyway, go ahead.
so in play here, they have forbidden a book which is nowhere concerned with history, culture, tradition, geography of state mentioned in the order issued, Lordship. So tomorrow, I believe, Your Lordship, none of us should be surprised or shocked if they go one step further and prohibit anything criticizing economic affairs or be welfare program of the state, Your Lordship. And so what I mean to say is, vague or even broadly defined restrictions, even if they satisfy the provided by law criteria, can still be unacceptable because sometimes they go beyond what is strictly required to protect the legitimate interest. And coming to Ramayana, Your Lordship, as there are as many as 300 versions of Ramayana are known to exist. And Your Lordship, in some versions, Ravana is glorified, called a great scholar and a capable ruler. And according to Buddhism, Dasaratha Jataka, Your Lordship, this version is notable for depicting Rama and Sita as siblings human. Your Lordship, now can we call all of them distorted or misrepresented just because it is not in accordance with what I opine or think about a particular character? Your Lordship, that would be very much incorrect on my part to be doing that. And Your Lordship, if you could refer to paragraph number 11 of the factual matrix, where Devanand Joshi stated that Ramayana is an epic, not an actual recorded historical series of events, and therefore he can write the book as he perceives it in any manner, which is true, Your Lordship, because the great Hindu epics, be it the Ramayana or the Mahabharata, fall under the genre of mythology, Your Lordship. Fall in genre of mythology, Your Lordship, and not history, Your Lordship. And Your Lordship, so Devanand Joshi's claim is absolutely right, and he has recreated or portrayed the famous mythology in a different way. And moving further to
Mr. Council in light of being, we have the author of Ramayana, Justice Valmiki is over here.
If Your Lordship could give me some more time because
All that we are saying is Valmiki is here. Yes, go ahead.
so, and one more thing is, lastly, if you could refer to paragraph 11 of Moot, where Joshi started receiving threats through social media and other platforms. One sub-objector by name Kanji Sharma threatened to chop off the hands of Devanand Joshi on his Twitter account. Your Lordship, is it not criminal intimidation? And that person by name Kanji Sharma actually has to be put under section 506 of IPC, which is within criminal intimidation. But why actually brought this before the court is because they prohibited Joshi's book as they wish to, but when it comes to providing security to Joshi, they failed to do so. At the same time, Your Lordship, even after being aware of all these developments, there is nothing said about Kanji Sharma. And Your Lordship, with this, my all my submissions pertaining to of the is complete. If Your Lordships have any question, I would like to.
No, thank you.
Much okay. Your Lordship, moving to last issue, whether the invocation of section 124A IPC is in contravention to the order of Honorable Supreme Court given by a three-judge bench in NC Mohammad's case on 11 May 2018. Your Lordship, the Council for Petitioner Moot reverently submits with the Honorable Court that section 124 of IPC is in contravention of the order of Honorable Supreme Court given by by 3 judge bench in NC Mohammed Khan's case on 11 May 2022, as the Honorable Court has clearly stated the operation of Section 124A of IPC till the re-examination of the section is complete and ordered that no fresh case shall be registered under the repeal section. So, if I have to speak about NC Mohammed Khan's case, Lordship, if you could refer to compendium, Lordship.
Where have we said that we are staying the operation? We have just said that we hope and expect.
No, Your Lordship, it has in a paragraph, Your Lordship.
We say that if there is any fresh case registered,
No, Your Lordship.
then you can always approach the court.
Paragraph number 8, D, Your Lordship. It says, in the, I have submitted the compendium. If you could refer to that, it says all pending trials, appeals and proceedings with respect to the charge framed under section 124A IPC be kept in abeyance. Adjudication with respect to other sections, if any, could proceed. In the court are of the opinion that no prejudice would be possible.
You have not yet reached the stage where a trial is pending. In your case, no prosecution is launched against you right now.
No, no prosecution is launched. Your Lordship, but these book
Under
items,
point 4 will not apply to you.
Your Lordship, the same section, these book
Why don't
items.
you allow that committee to examine the matter? Maybe they clear it.
No,
If
Your
they
Lordship,
don't
that-
clear it, or if they launch a prosecution against you, then you could have come. Is your petition
No,
not
Your Lordship,
premature?
regarding management, it has already been stated in the fact. Committee has already claimed that it is ultra stating that distortion of historical facts. Regarding management, it's pretty much clear. Lordship. Whereas Devanand Joshi is concerned, it is still under process.
Oh, yeah, well said about this Joshi.
Indeed, Lordship. Much already. So, in this regard, Your Lordship, moving further. Your Lordship, it clearly
Section 124
says-
continues to be on the statute. It has not been struck down.
It is not, but no, Your Lordship.
So therefore, but then there are certain restrictions have been put. If you file a case, you are entitled to be movers, not to proceed further. So the law is still there. So FIR can always be filed.
Indeed, Your Lordship. But when the Supreme Court order has, which says that if the till re-examination is done, this section should be kept in abeyance.
No, that does not appear to be from the which direction.
It is very much clear.
We have with us paragraph 8.
Indeed,
Which direction are you speaking of?
Indeed, Lordship.
In?
Paragraph number 8, Your Lordship. Paragraph number 8.
Yes, we have para 8 with us.
8D, sir.
8D.
D.
Point 4.
All pending trials
Shall be kept in abeyance.
Indeed,
No, no. So that is not striking down the section, or it is not said that you cannot file.
Indeed.
If it is filed, even earlier, if any fresh, if you read C, if any fresh case is registered with Section 28, the affected parties are of liberty to approach the concerned court for appropriate relief.
Definitely. Indeed.
So therefore, you will be entitled to bail, or the court may grant you bail, but
So, if Your Lordship, if they book under section 124, we have come for the appropriate behavior. Management has to be.
appropriate relief will only be granting you bail. What more can be granted at this stage?
Your Lordship, but still, Your Lordship, it's like business, it will be contempt of court because order clearly states that it is kept in abeyance.
You all have yet to make out a case why you must reconsider earlier judgment upholding the constitutional validity of 124.
Indeed, Your Lordship.
You must make out a case why you must reconsider.
Your Lordship, actually, it was upheld in Kedar Singh versus State of Bihar. But that was a constitutional bench, and this is the bench, Your Lordship, I see.
2 minutes,
Much
2
already.
minutes.
In this case, Your Lordship, it is the moment there is order is passed by 3 judges. Your Lordship, so it is against, if they pass, if they cannot strike the order because it is against the principle of judicial discipline and propriety. So, Your Lordship, we are here before the 7 judge bench so that we can.
Also, that can't be answered. A larger bench can only answer a reference made to it by the smaller bench. Now, if the constitution bench has referred the matter to a larger bench, then we can consider it, but we are not at that point. What is the point for us to reconsider? Your colleague has said it has a chilling effect.
Indeed, Your Lordship.
So therefore, what according to you, other than chilling effect, is the reason why we must consider?
It even doesn't come to children, but innocent, if he has to say, if he has to express anything against the government, then that person will again, he'll always be in the impression that I may be booked under section 124. So considering all this and chilling effect,
Kedarnath, we have also explained what are the meanings of the various terms used under section 124A. How there is a difference between mere criticism of the government and waging war against the state. So if those safeguards are followed, still should 124A be shut down? What happens to cases where somebody actually wages a war against the state or incites any violence to overthrow the state?
Indeed, Lord.
What adding to what my brother has said, merely because the section may be misused, we'll put it that way. Is that a ground to strike it down?
No, Your Lordship. At the same time, Your Lordship, if you could refer to the data passing the judgment, Your Lordship, that para number 37 of the complaint, in the complaint.
Yes,
Where it clearly states that it is said that it has not been contended before us that if a speech or a writing excites people to violence or have the tendency to create public disorder, it would not come within the definition of sedition. What has been contended is that a person who makes a very strong speech or uses very vigorous words in writing directed to a very strong criticism of measures of government or acts of public officials might also come within the ambit of penal section, but in our opinion, such words written or spoken would be outside the scope of section.
So therefore, we have clarified that simply because there is a vigorous criticism of the government of the day, 124A is not attracted. If somebody misinterprets it and goes against you, you are ready to ask for striking down the provision. Or you can defend yourself and say that 124A doesn't apply. You ask for quashing of the FIR.
You know, along with chilling effect and prudent advertising, I have some data as we speak, which actually speaks a lot about suppressing the dissent or vice of criticism.
you may file that with written arguments.
But it is by
You may file your data with your arguments.
It is by NCR.
So thank you. Anything further?
I would like to conclude by quoting former Chief Justice N.V. Ramanam, who actually expressed concern, saying that sedition law was like a saw in the hands of carpenter who were not to cut wood, start cutting the forest. That would be all in logic. If you logic society to continue, I would like to proceed. The logic much obliged. Therefore, in light of issues raised, arguments advanced, authority cited, counsel for petitioner most humbly and respectfully praise that this honorable court may kindly adjust, hold and declare that first the order passed by the Ranpur government on August 15, 2022 violates fundamental rights enshrined in this. Secondly, section 124A in this penal code is violative of fundamental rights enshrined in this. Thirdly, the government order requiring Joshi Group to submit it for pre-publishing review and essentially of the fact is certainly violating fundamental rights. And lastly, the invocation of section 124A of IPC is in contravention of the order of Honorable Supreme Court given by 3 judgments in SC Bombas case on 11 May 2022. Lordship, therefore, the order in question, that is order by state of the court, should be set aside, and the improved section, that is section 124A for the 7 judgments, should be struck down, along with the release of Parent Jamil and the ban on Devanand Joshi's book should be lifted. Or pass any other order, relief, directions that the Honorable Court may deem fit in the light of equity, justice, and good conscience, and for this act of kindness, the petitioner shall forever humbly pay. Counsel, let's the case, Your Lordship, before the pleasure to be with Your Lordship.
Thank you. Apart from this, we have financial gains.
Yes, sir. Respondents. It's a companion.
Compliance for judgments.
Yes.
Okay. Yes, counsel.
Greetings, Your Honor. And counsel. And the counsel inside of response. Your Lordship, I'll be dealing with issues 1 and issues 3, whereas the co-counsel will be dealing with issues 2 and issues 3. Your Lordship, with regards to issue 1, the petitioners have challenged the constitutional validity of the order dated August 15, 2022. Your Lordship, via an order dated August 15, 2022, we have formed a screening committee which is formed with the intention to prevent distortion of facts and to maintain peaceful coexistence amongst individuals. Your Lordship, this screening committee.
Now, before you proceed, what is the basis for your which is the power in you to appoint this committee?
Your Lordship, under the power vested in Article 162, there is an executive power that the government is exercising. By the executive order, we are trying to provide restrictions, reasonable restrictions, which is mentioned in Article 19 subclause 2, on the rights of fundamental rights of Article 19 subclause 1 subclause 3 of the Constitution. Well, also before I proceed further with the merits of this case, I would like to submit that since they have challenged the validity of this order, and the primary argument is that it's unreasonable under Article 19 subclause 2, it becomes very prohibitive for this to test upon the validity of Article 19 subclause 2 on two grounds, whether the restriction is reasonable and is it in the interest of the 9 grounds which are mentioned under Article 19 subclause 2. But also before I proceed further, I would like to draw your attention towards the factual context under which this order has been placed. But also I would like to draw your attention towards para 5 of the Moot Constitution.
Para 5 of?
The Moot Constitution, the facts.
Okay, yes. Go ahead, please.
Philosophies are which and in the late 1970s, this led to armed conflict. Well, this refers to the demand of a separate state by particular communities and also ethnic discrimination being done by Medis, which was towards the Banglas and the Hindus. Well, there were already a demand for a separate state and ethnic discrimination. The state was already a dominant. Further, I would like to draw your attention to para 6. On September 8, 1980, Andhra was declared an area of disturbance where the English government imposed the Armed Forces Special Powers Act. Your Lordship, the Act still and in the present time continues to remain in force. And further, Your Lordship, in paragraph 7, it's mentioned with utmost difficulty, even by deploying the Indian Armed Forces, the peace was established by the end of 2005. Your Lordship, it took a total of 25 years for even armed forces and the Indian Army to establish the peace in this region. And Your Lordship, till now, Andhra continues to suffer from the movements of innumerable underground organizations, but also from a complex ethnic crisis. Under this context, Your Lordship, the government has imposed this order with the intention to curb misinformation. Your Lordship, the first clarification that the Council would like to submit is that the government has not at all banned any book. There have been two orders with regards to what the petitioners have the right to the book. The first petitioner, Your Lordship, Mr. Merrick's order. This book has been opined by the government, by the committee, not by the committee, to be baseless and false. But also before proceeding further, I'd like to state that this very book has elaborated on the definition of reasonableness. This definition.
So before you go to reasonableness,
yes, sir.
Will this order of yours be supported under Article 19.2?
Yes, sir.
Which part of 19.2 will be supported?
Your Lordship, we have issued this order under in the interest of sovereignty and integrity of India, security of state, public order, and prevention of incitement.
So that has to be, I assume, under law.
Yes, sir.
Is your executive order law within the meaning of Article 19.2?
Your Lordship, I would like to draw your attention towards Article 14, subclause 3, clause B, which refers to law in force includes laws passed or made by legislature or other competent authority in the territory of India. This read in conjunction, this read along with Article 162, Your Lordship, which reads as subject to the provision of this Constitution, executive of the power of the state shall extend to the matters with respect to which legislature of the state has the power to make law. With this, the state had the power to pass the state law. And
are not these expressions used in the context of subordinate legislation or conditional legislation? Are these expressions in the context of administrative action or executive action, or in the context of legislation, subordinate legislation or conditional legislation? Can you read administrative law into Article 13? Because in that manner, the state can assume all power in itself and curb every free speech.
Mr. Counsel, if your argument is to be accepted, then perhaps the legislature cannot enact such a law. But by an executive action, you will be able to curb the fundamental rights. Is it not settled law that if you want to impose restrictions under Article 19.1, then it has to be by a law? Law means a law made by the legislature, or maybe an ordinance, which also has a legislative.
yes, Your Lordship, I agree to your argument, Your Lordship, but under Article 162, mention an executive authority can make law at par with the legislature.
No, no. Does it say so?
That's what I'm reading.
162 is exercise of executive power coextensive with the legislative power. It is not law-making power. In the absence of law, see the law as now held or interpreted, that where there is a vacuum, for example,
Yes, sir.
then you may make, in the absence of a law, issue administrative instructions. Otherwise, administration is going to come to a standstill. It does not mean that you can take over the field left to the legislature.
Well, also the council, with the limited power that the council possesses, would like to contain that this order established is a peace-keeping committee to screen the flow of misinformation and also with regards to the turbulent state of affairs in the state of Andhra. The order is not, being it an executive order, has formed a committee independent from the government, composed of academicians and highly trained experts who are vice chancellors of the university and professors of the university. With this fellowship, I'd like to state that.
See, as the note says, between 1970 and until 2 years ago, there were no such restrictions on publication, printing of anything. Now, what makes you suddenly in the 2020 or thereabouts?
Well, also the condition in the state of Andhra is such like a power takeover. There already a demand for security of state at stake. They are demanding for a separation of the state. The government, with the help of the
Those are legitimate demands of any section of the people living in India.
agreed a lot.
Based upon their culture, based upon their whatever it is, they may demand it. As long as it is merely because somebody wants to articulate a point of view,
Yes, sir.
and that our point of view may be in tune
Yes, sir.
with what somebody else is expressing.
Yes, sir.
Will that be a ground for suppressing speech?
Well, also, the council submits that there has not been a suppression of speech. We have not banned anything. We have made the objective to speak. Well, also, the factual scenario in which we have done is that even after 24 decades, the government tried to establish peace in Southern India. The petitioner Derek John came and published a book which he contended to be. Well, also, this book was published in September 1st. On September 15th, he gave an interview and spoke about the book. This led to debates and reiterated the demand of a separate nation also. And that part is trying to establish that they want to separate from the nation of India and be a part of the separate nation. What the government by this order dated September 30, and an order of this committee which is formed under order dated August 15, 2022. This committee only opined that they are baseless and false. Well, also, the contents and the intention of the committee was to only question those debates. Your Lordship, I and Your Lordship are having a discussion. That discussion is based on a book known as the Constitution of India. If a person comes and challenges or makes that the Constitution not accurate, it questions the discussion that we are having. And in the interest to maintain public order, and the interest to maintain public order and maintain security, the government will only made it reasonable, and the committee only made it reasonable to question and certify that the facts that are mentioned are not accurate. Just to keep a check and to maintain the public order situation, stating that they are not completely accurate, so to curtail the disturbance and peaceful and establish peace again in the country. It is completely within everyone's right to express their opinion in whichever manner they need to, but that should be restricted to the reasonable restriction enshrined in Article 19. And in the interest of this, which is a very wide ambit of public order, we have passed this committee. If the petitioner feels that the committee is formed or acting biased, they are free to approach this court of law. Because in any case, Your Lordship, they have drafted something which is against the nation, they will eventually be tried and will eventually be presented before this court of law. But to curb misinformation, because the dominant state of affairs in the state of Andhra is like a power play. Any kind of misinformation would act as a spark in that power play. And as I've established, it took 4 decades to establish this, and the government is trying all its resources to maintain that control. Therefore, Your Lordship, the council contains that it is reasonable, Your Lordship. And further, Your Lordship, containing the respondent's argument, Your Lordship, the respondent has elaborated on the case of Lalit, the state of Mr. Lalit Singh Yadav, wherein the ban which was imposed on a book called Ramayana or two readings was struck as. Your Lordship, the in the present case, this judgment is not actually as no back traffic stop. Only it has been opined and that the book is based on it. The book has not been banned. Secondly, or also
No, no, just a moment. What is your argument? Committee has taken a decision the book is not banned. They are coming over here because the book is banned, I assume.
No, we are the respondents, but defending the constitutionality of the validity of the committee. They are here challenging the constitutionality of the committee that is formed. The question before this bench is to determine whether the committee which is formed is constitutionally valid or not. They have challenged it on the grounds of not being reasonable. And also they have challenged.
So you are trying to distinguish the judgment. That judgment dealt with a challenge to the banning. That is not the issue. That is the okay.
And the logic firstly they have categorized in Article 90 which have discussed. Then they challenged it on they tested it on the validity of Article 14. The logic Article 14 they have stated that there is no inconsistent differential as they have only provided a restriction on books and not on articles and magazines. The logic the council submits that books have formed the basis of this document. Books, they have a substantial amount of content which forms the basis of the debate and when entire debate which lead to such kind of thing. Therefore, there is no way to certify whether the book is accurate or not. There is some kind of mechanism.
What is the difference in the written word? What is the difference in the written word publishing in a newspaper, in a magazine, and in the form of a book? Now tomorrow I might write various articles in the newspaper and thereafter try to put them together in the book. Whereas I can write in the newspaper or publish it in this, nobody will screen it. But the same article, if they put them in a compendium and publish it, we say no. Now come to us. Now what is the intelligent difference over here?
Well, also, to simplify, just the argument of the fratricide petition is.
Forget about them. How do you justify?
Well, also, we don't justify that. Well, also, we simply say that we issue another order going by this thing. Because if they are challenging the constitutionality of the order, they can't come here and tell us that if we are filling the glass half full, but it's half empty, so we throw the glass.
No, their point is very simple.
Yes, sir.
Here there are two. One, periodicals, newspapers do not go before the committee. Books go before the committee. Now how is this classification reasonable? What is the differential which separates the two? Both are written words. How do you distinguish between the two?
Well, also the ability of a book to ignite debates because the justifications given by the author are complete in nature. The accuracy of a book I deem to be more than that for articles because there are thousands and millions of articles published per day. If an article is published, an article countering the same language is instantaneously watched. Therefore, there cannot be spread of misinformation that easily by everyone. But a book which is substantiated an argument to that level of needs to be firstly needs to be justified in that. And they are also the side respondent not to exceed, not to be excessive in applying this restriction has limited to a book. If the time may come, the restriction may be applied when only if the surpasses the test of reasonability etc.
Okay, proceed.
Yes, sir. Well, also this
they have counsel by that logic.
Yes, sir.
You will even prevent people from speaking in their own houses. You will say that nobody should even speak anything on this topic unless they take a prior approval of some committee.
No, the contention is not in regards.
What is there to prevent? You are saying that we might now issue a similar order for paper publications. The step would be that don't even speak.
The contention to respondent is not to limit speech to that extent.
So you are saying that get our approval first and then speak if we approve.
The approval is only in regards to the order passed in the petitions that came with it of challenging the constitutionality of that order. But also moving further with issue number 3 where the petitioner Devan Joshi has written a book known as Ravana's Ramayana, wherein he has portrayed Ravan in a greater character that justifies his action, such as abduction of Sita, and question the character and the virtue of Ram by questioning the killing of the sister of Ravan. And therefore, this book has offended the majority Hindu community, not only in the state of Andhra but in the entire nation of India. But also the respondent contends that Before even its publication, the book has not yet been published, Your Lordship. Only on the Twitter handle, Your Lordship, he has mentioned certain details, and that has led to such wide protest, Your Lordship. Your Lordship, the council submits that in the interest of public order, the government has still not banned it. The government has stated that just because it has caused such wide massive protest, not only in the state but in the entire nation, they have simply directed the book to submit before the committee so that they can be. There are three instances which can happen when a committee is claims the book is either accurate and correct in terms of facts, the book is either inaccurate and incorrect, and thirdly, the book either offends certain sections of the people. If the book is correct, the committee can. If it is incorrect,
also these are epics.
yes, sir.
Who vouches for the correctness of the facts in any epic? Maybe any epic we take, who vouches for the correctness of the facts? It's a perspective of somebody has written and accepted over a period of time that this is what is there. A belief thereafter of what is there. Nobody knows the facts.
Your Lordship, the
The
category
majority does not believe it. They are free not to believe it.
the category is called the third category of offending religious something in the regulation, not the first two.
For that, you have enough provisions even under the IPC.
Yes, Lordship. But Your Lordship, we do not intend to ban the book, Your Lordship. Your Lordship, I would like to submit a judgment of this honorable
Because you have relied on K.A. Abbas. Now, does K.A. Abbas not make a distinction between the medium of movies and written books? And possibly it is K.A. Abbas which says that for movies the impact is immediate,
Yes, sir.
and therefore pre-censorship is valid.
Yes, sir.
But for books, or even I think for dramatic performances, pre-censorship has been struck down.
Agreed, Your Lordship. But pertaining to the situation in the state of Nagpur, there is a turbulent development. The threshold of reasonability.
Constitution applies to that state also.
Agreed, Your Lordship. But the threshold of reasonability differs from state to state and matter to matter, as held by the Golden Statement of PG, which is in the comparative
So
standard.
therefore, if you find that after a book is published,
Yes, sir.
if you find that there is some problem or it attracts any of the provisions of the IPC,
Yes, sir.
you take action.
Your Lordship.
But why pre-censorship?
Till that time, the duration between the book is being published, the impact that it has caused, the already turbulent situation of the lawsuit, people already the mentally farmers and coolies are fighting a lawsuit. There's existing discrimination existing in mind. Now we don't want another new government to protect a lawsuit. The government
They were fighting before the book.
before the book has reiterated the demand, and it is so difficult to fight.
Council, the question is the larger question.
Yes, sir.
To what extent is this code going to, I will use the word chain Article 19? How long can we ask people not to have a intellectual discussion by way of writing on an aspect of, you may believe in A, member of your same community may have a different view on the same point. Now, because you believe or a larger section believes, is he prevented from writing his point of view on the same epic?
Your Lordship, that is what the committee is meant to be screened. Whether
The committee will examine whatever it is. We are asking you a larger question.
yes, sir.
Freedom of speech and expression is that we as Indians are in a position to articulate our thoughts. And the best expression of free thought is writing. The written word is the best articulation of free thought. Now, how are you going to change this free thought by dividing into segments? Because section A does not like it or will be found offensive. The rights of another person to write his opinion on the same epic, can it be taken away?
Your Lordship, I completely agree with your Lordship's contention that such rights cannot be taken away. But your Lordship, free speech must also lead to public opinion. To not to an absolution but to a certain extent. A book which has not yet been published has led to disruption of public order in the entire nation. It is extremely easier for it to be screened as to categorically test whether it is offending, deliberately has the intention of offending certain section or not. Because your Lordship, if you refer to the contents of the book, Ramayana, read as may an epic, but for the Hindu religious community, Ram is a symbol of vices, a symbol of virtue and good conduct, and Ravan is a symbol of evil.
But the writer, the person who wrote the book is also a member of the same community.
Read your Lordship, but he has challenged the entire basis He has challenged, questioned the entire faith. Ram is treated as a god by the Hindu community. And he has challenged the entire symbolism for its child. A story may be anything. It is the value of a story that stands in the minds of the people that faith behind.
Absolutely, at the highest an unpopular view, let us say.
Yes, yes.
But the fundamental rights are meant to protect unpopular views.
Yes,
Isn't it?
agreed, Your
If
Lordship.
a view is popular, then it requires no protection under the law.
Agreed, Your Lordship.
So therefore, in such a situation, do you not think that the answer is in greater freedom of speech? So that let there be a debate, let the majority let there be a discourse, and let the majority point out the errors into which this author has fallen.
Your Lordship, at a nationwide level, the contention of Lordship is agreed by the government. But in the state of Andhra, Your Lordship, it is a prohibited one. What the government, in the interest to maintain public order, has made directors committee so that we can screen it. If the committee finds
Even if we assume that your ends are justified, in constitutional law, the means are more, or in fact more important than the ends.
yes, Your Lordship. Your Lordship, but let that disclosure be done peacefully.
In that way, you will say that the best way to have peace is to determine which people are unpopular and keep them in the prison.
Your Lordship,
There will be absolute peace. Peace of the graveyard, as one of our judgments has said.
Your Lordship, the contention of the order which is directed the petition submit this book is not to completely restrict him to publish his book on it, Your Lordship, just to maintain security and the disclosure that Your Lordship is talking about, for him to completely express his right freely. And because in the interest of the petition itself, Your Lordship,
See, the council will give you 2 minutes, but what will the committee decide? Committee will decide one, either to that a book should be published or not to be published. So these are the only two choices. I mean, but then what happens if the committee decides that this viewpoint is against the committee's viewpoint, whoever it is, or against what perhaps the government of the day thinks?
Your Lordship,
Then what happens? What happens to free speech?
Your Lordship, the third scenario is also. We do not live, the committee is not formed to give a biased decision or to allow them not to come. It is to assist such publishers.
The council nowadays committees are, as you know, the wording used packed. So there is no mechanism by which all people of all thought process will be included in the committee. Committees normally are by the government, and normal selection is of those persons who subscribe to that philosophy.
Your Lordship, this committee which is formed composed of extremely varied professionals, first Your Lordship. Secondly, Your Lordship, the third thing that we are not a binary committee which will be the approval that. We may even direct the petitioner at the judgment that are submitted before you, Your Lordship, of this bench, wherein a similar question was raised. A person had written a book on the life of the saint, whose life was very relevant and people had faith in that person. He had questioned certain character of the person and mentioned certain facts which were thought to be offensive by the followers of that country. The book was challenged by the same community, and the Supreme Court has upheld the order of the country. The Supreme Court also had directed the petitioner that if you may separate the part that is offending, there will be 3 or 4 paragraphs in that book that were offending. So that is what the intention of this committee is about. If not only this book, but in the larger interest of if it comes to notice of the committee that there are in the entire section of the book, there are certain parts which are maybe offensive or which are.
See, there was this book on Chhatrapati Shivaji written by one Lane. Now it was last section of the Maharashtrian community. They were against the view taken by Lane. Now Lane is a historical professor. Now that ultimately that order by the government of Maharashtra was struck down. I don't know whether ultimately sitting in the High Court I had struck it down, but the matter went up to the Supreme Court. I don't know. Ultimately, I think the order was upheld. I think it was upheld. See, ultimately, we are custodians of the right to free speech. We understand that there can be reasonable restrictions on that right, and that that has been understood by by the founding fathers themselves by putting Article 92 in the articles. But there has to be some line where free thought can't be changed. Let us hear your other counsel. Yes, please. Now, counsel, we are only asking questions. We are asking questions so that we know your answers. So don't take it that we are for you or against you.
May please quote, this is counsel number 2 appearing on behalf of the respondents in present matter, and the counsel shall be dealing with issues number 2 and 4. Before proceeding any further, the counsel seeks permission to collectively address the rights of your lordships. Much obliged. The lordships, with respect to issue number 2, the question before this court is whether section 124A of the British Penal Code is violated of the fundamental rights as is enshrined in the Constitution of India. It is submitted, your lordships, that section 124A of the IPC is ex post constitutional because it is not violated of Article 14 and 19 clause 1 subclause A of the Constitution. To begin with the first length of my submission with respect to Article 19 clause 1 subclause A, it is submitted, your lordships, that all citizens have the right to the freedom of speech and expression. But this freedom is not absolute. It is subject to certain reasonable restrictions. In the case of Kedarnath Singh versus State of Bihar, this very court has held 122A to be improvised the Constitution and in consonance with Article 19 clause 2. Article 19 clause 2 provides for certain reasonable restrictions. The reasonable restrictions include in the interest of public order, sovereignty, sovereignty and integrity of India, and the security of state, with many more which includes friendly relations with foreign states, public order, decency or morality. It is submitted, your lordships, that man, as a rational being, desires to do many things. But in a civil society, his desires have to be controlled, and liberty has to be limited in order to be effectively possessed. In this, the disturbance of public order has been recognized as an essential ingredient of sedition. Moreover, as per the Law Commission of India's consultation paper on sedition dated 2018, 124A must be read in consonance with Article 19 clause 2. Now if I can refer to draw your lordship's attention to para 11 of the Moot proposition. It has been stated that on 15th of September, the petitioner spoke extensively in an interview in the news channel and reiterated that what he had written was correct. Now this has led to ignition of demand by the Bangas for a merger with Bangaland and for a separate state. I was demanded for by the Kurtis, which is another community within the state of Dhaka. The lordship is submitted, the expression in the interest of public order has a very wide connotation and should not merely be confined to only one aspect of public order, that is incitement to violence or the tendency to violence. Public order can be affected in other ways also, and creating disaffection, hatred or contempt towards the government established by law may seriously affect the interests of public order, even though there may be no tendency to be incitement to violence. So you also have to keep in mind, in Kedarnath Singh, the court held that when words, either written or spoken, have the pernicious tendency or the intention to create public disorder or disrupt law and order, it will fall within the interests of public order. Moreover, with respect to Article 19, it is submitted that what is sedition, your lordships? Is it a feeling contrary to that of affection, or is it the mere absence of affection? It is submitted that it is a feeling contrary to that of affection, and in the present case, the petitioner, by his very book, and on top of that his interview, it has led to ignition of a demand, and hence this would disturb public order and would fall within a restriction as per 19.2, with respect to the public order restriction in 19.2. Moreover, this is with respect to Article 19 clause 1 subclause A. 124 has been meant to be improvised in the Constitution. Now with respect to Article 14, your lordships, it is submitted that the state shall not deny to any person equality before the law or the equal protection of laws within the territory of India, and to pass the test of Article 14 two conditions of the fulfilled. That is, the classification must be founded on an intelligible differential which distinguishes those that are grouped together from the others, and the differential must have a rational relation to the objects of the election. Now in the present case, The classification is founded on an intelligible differential between those who bring or attempt to bring the government into contempt of hatred and those who don't. Similarly, there is a real and a substantive difference between those who excite or attempt to excite disaffection towards the government and those who don't. The objective of the intelligible differential in the present matter is to ensure that 124A only penalizes words that reveal an intent or tendency to disturb law and order or that seem to incite violence. Moreover, the differential has a rational relation to the object sought to be achieved as it seeks to punish those activities that are anti-national, secessionist and terrorist. Now, it is noted that the petitioners in the present matter, particularly Mr. Menon Gudi, is a PhD from the University of Yale in archaeological anthropology. But no matter how high you will be in society, as per Thomas Fuller, the law shall always be higher than you. He cannot publish.
Counsel, may I ask you a question?
Immediately.
If tomorrow somebody sitting in Sikkim writes a book that Sikkim was never a part of India until X day. Now, if he writes that, will his article be attracted? Well, now he's saying Sikkim was never a part of India.
The logic, if it disturbs public order or if there's a pernicious tendency to disrupt law and order, then it will be Article 19.
So how does a person writing history know the consequences of how his written word may be misused by somebody else?
But that is the very contention of the Council, Your Lordship, that there is, even if there is a tendency.
Today the law has been upheld.
Yes, sir.
They are asking for a larger bench to reconsider, and if I may, the expression that we have used, it's a new expression in law, chilling effect.
Yes,
That seems to be the expression that they have coined for us to reconsider. Why should we not reconsider?
Your Lordship, even as for Article 141 law declared by the Supreme Court is binding on all Indians.
No. We are now a larger bench. That was a constitution bench. We are now a larger bench. So a larger bench can always reconsider.
But it is submitted that it is constitutional.
And larger benches are constituted only when a matter is referred to them for reconsideration. So assuming that this matter has been now before us for reconsideration.
You know, it is the contention that 124A is a reasonable restriction under Article 19 clause 2. Moreover, it satisfies the test of Article 14 as well. That is the contention of the Council. And so there is no reason to declare it unconstitutional.
So according to you, Machiavelli is right.
Because Lord Machiavelli. The law of sedition and also, sir, English has had a checkered history with respect to sedition.
Then, Mr. Counsel, your arguments are very similar to the arguments of the prosecutor in Bal Gangadhar Tilak's case.
In Bal Gangadhar Tilak was held.
And at that time there was no constitution. All that Lokmanya Tilak was saying was that the British governance of India should be overthrown. We have a right of independence. He said Swaraj is my birthright. Do you want to have that kind of prosecutions when our constitution still holds the field?
The Lordship's Kedarnath Singh's judgment has narrowed the scope of sedition. That is the submission. It is narrowed.
Therefore, they also did not approve the view in Bal Gangadhar Tilak by narrowing it down.
Yes.
If your submission is to be accepted, then what we are accepting is the full-blown view in Bal Gangadhar Tilak's case. And that is why they say that because such attempts are being made, it is better that 124 is struck down. That's how they will come to a 7 judge.
And the argument is there are other laws which can deal with the issue. Unlawful, Terrorist Act, unlawful.
The Lordships, the government counsels in the petitions have cited a chilling effect. But chilling effect is no defense in law. Moreover,
Chilling effect is a ground to strike down the law, as was done by in that Shreya Singh's case. Because there it was the same thing, that in electronic media, if you write anything, then the argument was that you are liable to be prosecuted. The Supreme Court said this will have a chilling effect, it will not allow anybody will be scared to even speak.
with respect to the reasonable restrictions in 1992, the restricted public order is very wide. So it is not that there has to be public disorder that is lost put on it by Kedarnath. Even if there is a reasonable anticipation of it, it will fall within a reasonable restriction under Article 22. And hence, 124A is constitutional and not violative of any article that is per se Article 14 and 19. That is the condition.
See, council, only thing is if we accept such views, a minority of whatever hue will never be in a position to articulate its views. Because the majority and we will always prevail on the ground of public law and order. A majority can always raise the issue of public law and order. So the view of the minorities can never be heard. When I mean minorities in the matter of expression, thought process, or anything across the board.
The Lordships, with respect to Kedarnath Singh, although the court held that Section 122 was improvised the Constitution, it permitted for disaffirmation and criticism of the government. Moreover, with respect to that, it stated that the extent of allowing disaffirmation and criticism of the government, but that is also until it reaches the threshold of intention or tendency to incite violence. So the confession given by the court in Kedarnath Singh was tactically meant to save the sedition law from being declared unconstitutional. And that is the contention of the council.
So according to you, we should not reconsider.
Logically, it's the contention that 124A should not be declared, should be declared, it is constitutional, and should not be declared unconstitutional. That is the statement. If your lordships are content with the submissions with respect to issue number 2, the council seeks permission to move on to issue number 4. Your lordships, with respect to issue number 4, the question before this court is whether the invocation of section 124A of the IPC is in contravention to the order of the Honorable Supreme Court that is given by Judge Bench in S.V. Mobekare, dated 11th of May 2022. Your lordships, firstly, in Kedarnath Singh, the court has opined that it was well settled that if certain provisions of law construed in one way would make them consistent with the Constitution, and if other interpretation would render them unconstitutional, the court would lean in favor of the former construction. Moreover, your lordships, if the council could draw your lordships' attention to the written submissions of the petitioner, that is, the memorial to the petitioner, page 32, para 63A. Your lordships, in that particular para, the petitioners have quoted the order of the Supreme Court, wherein they have stated that the state and central governments will restrain from registering any FIR, continuing any investigation, or taking any coercive measures by invoking section 124A while the opposite provision of law is under consideration. The lordships, in the petitioner's written submissions, the learned counsels to the petitioners have very skillfully omitted the words "we hope and expect" in that very order. They have omitted the words "we hope and expect," and that is very crucial. We hope and expect. The courts have requested the states not to file any, not to register any, to refrain from registering any FIR. Moreover, this direction, rather not a direction but a request from the court, the lordships, is very vague in nature, because if we go to see the same para A, sub-para F, it is stated that the above directions may continue till further orders are passed. In that sense, this order appears to be prima facie interim for the very reasons that the operation.
No doubt you are right. It is an interim order.
Yes, sir.
But just because you use the words hope and expect.
Your lordships, it is noted that judicial language is chaste and courtesy is the blend of an order. But with that being said, it is
when we request the High Court to decide a matter expeditiously,
yes, sir.
we also say that we request them. But then our request was literally considered as request, and we had to clarify that when a request comes from the Supreme Court, it is in the nature of an order. It is only out of constitutional committee that we use such polite words. This is euphemism.
Your lordships, with that said, had the court stated in its order the direct the state not to register an FIR, the wording here is we hope and expect.
No, you are right there, counsel. A reading of the order is that you can register an FIR. That's provided in the order itself. Then the party can approach the court for interim relief. But these were all interim directions which were pending pending the hearing and final disposal of the matter. Now the matter is before us. See, ultimately this matter with directions were issued was the interim direction because the government said they are going to re-examine.
Yes.
Now what has happened to re-examination? Has the re-examination happened or you have no instruction on that
It is under
matter?
consideration.
But how long will it consider till kingdom come?
In due course of time, it will come your way.
This order was passed when?
So, Your Lordship, the order is the SG Umbedkari order is 11th of May 2023.
Yes.
But with that being said, we also have to keep in mind that Section 124A, as per Schedule 1 of the CRPC, is a cognizable offence, a non-bailable offence, and a non-compoundable offence. Moreover, the investigation of offences and the prosecution of offenders are the duties of the state. This court, with all due respect to Your Lordships, cannot direct the police not to register an FIR in a cognizable offence, because that would be in contradiction with Lalita Kumari.
Council, the court has not done so. The court in direction 8C has left it open. The court has not said he cannot file. But if filed, don't proceed further. Then the party has the right to move the court for whatever relief they have got. Don't you think council is a very draconian provision?
The Lordship, it is not at all draconian for the very reason that even in the present case, the petitioners have approached this court for relief. With that being said, in Para C itself,
They had a right because they are not going inside jail mercifully.
in Para C as well, Your Lordships, it has been stated that any fresh case is registered under Section 124A. The affected parties are at liberty to approach the concerned courts.
That's correct.
The judgment has not stated approach this court.
No, of course, we can't, every bail matter can't come before this court.
Absolutely, yeah.
It has to go to the competent court, which is the magistrate, and the jurisdiction therewith.
Yes, Your Lordship. But in the present case, the petitioners have approached this
As
court.
a council, if they were to approach the High Court, then perhaps the High Court would have some difficulties in examining the constitutional validity of 124A, considering that there are Batsha.
Yes, sir.
But a 7-judge bench will not have that difficulty.
Yes, Lord.
That is why they come here.
But even the prayer of
Yes, correct. This is the matter.
And more so, because this matter is under consideration before us.
yes,
The interim directions were issued before us, so therefore they are right in coming under Article 30 before this court.
the Lordship, but even the prayer does not state anything about quashing the FIR. The petitioner in the present matter has been arrested under Section 124.
They are raising a larger constitutional issue.
These are two separate issues.
If that is allowed, then the FIR will go with the dustbin of history.
If 124A is struck down, then where is the question? What happens to the matter?
The contention was that there are Section 2 and 4 were two separate issues in this regard. That was the contention. Moreover, Your Lordships, the past cannot always be erased by any judicial declaration. The present abeyance of proceedings, even before declaring 124A, Your Lordships, is in a way against the doctrine of prospective overthrow. Because when the court finds or lays down the correct law, the court restricts the operation of newfound law to the future, so that its impact doesn't affect past transactions. As per SG Umbedkari, it affects past transactions as well. Hence, it is
No, that depends upon the power. The court can always say, restricted from the particular date, or can say that for all times to come, so we are struck it down applies to everything. But may say something. That is always the power that in the court. From what day the judgment should be declared to be valid. So those are within our ambit. If you strike down the law, of course it does not mean that conviction already undergone will be resurrected. That will not or effaced. So those are separate and not issues which perhaps arise in this matter.
very well. So on that note, the council raises submissions and seeks permission to move on to the prayer.
Yes.
Therefore, in light of the issues raised, arguments advanced, authorities cited, and reasons given, may this court be pleased to vote and declare that the impugned order dated 15th of August 2022, issued by the government of Kanpur,